To stop retrenchments at the SABC presented in the Labour Court in Johannesburg. Let's get the very latest now and bring in our reporter Mbali Mthethwa live for us there. Mbali, thank you very much indeed for coming on. What did you hear at court today?
Good morning, Blaine. We've had quite a morning here at the Labour Court in Johannesburg, where we've heard arguments between the SABC and SABC Union BEMAWU. It seems there's been a breakdown in the trust relationship between the SABC as well as the union. The union is accusing the SABC of negotiating in bad faith, and the SABC's lawyers have dismissed the claim, saying that they have had 16 consultations with the unions. However, the lawyers representing BEMAWU have said that the union has not, the SABC rather, and management has not given them an opportunity or fair chance to discuss other things such as, the mitigation of some of the retrenchments, the payment of the severance packages, as well as, the selection process as to how these individuals who have been awarded these redundancy letters, to be exact, were selected, and if indeed they will be still be handed over those letters at the end of the 31 days on the 31st of December. But I'm not alone here. I'm actually joined by Union President, BEMAWU Union President, Johannes Buisson. Thank you so much for speaking to us. You've made an argument and you would like the courts to force the SABC to go back to the consultation process. Talk to us about what you hope to see come out of that.
Well, the SABC has already agreed to consult. That is after we filed our application. The reason why that application was not withdrawn is because the SABC previously undertook to properly consult. We then removed that application from the roll, and what happened thereafter was our members were served with termination and redundancy letters. What we want the court to pronounce is that there will be proper consultation. That offer that has been made by the SABC of the 30 days must be made in court order. And then the major issue and stumbling block at this point in time is the fact that those termination letters are still valid. It has not been withdrawn. That means that the SABC's decision, which they've taken on a flawed consultation process, has not been reversed. And that is an untenable situation because we cannot continue to, that would be consultation in bad faith from the SABC side, because clearly they've got an end goal in place. They just want to take us along another road to that. So if the SABC is sincere in their attempts to consult meaningfully and genuinely, those letters must be removed.
So we heard the lawyers representing the union discussing the fact that this is could possibly be a ploy to remove the steam that's already gathered and all that has been happening around this section, and only to then reinstate the letters at the end of the month. And we've also heard your lawyers just speaking about the difference between a negotiation and a consultative process. Please talk to us about those arguments.
We know, and we've never asked the SABC to negotiate on anything. We know it's a consultation process. We know what's the nature of that process. So the SABC has misrepresented facts in court if they have said to the court, and they have said to the court that they think that we want a negotiation process, which is not true. So yes, we want proper consultation. We've never said that it should be a negotiation process. The issue around the trust relationship and so on, that is based on the fact that the SABC previously has said that they will consult with the previous application, and then they issued people with letters. So naturally there is an issue around trust around that. There is not, and there is nowhere in the papers, as has been eloquently argued by our counsel, there is nowhere in the papers any indication whatsoever where we said that there is a total breakdown of the trust relationship between employer and employee. Of course, there is a lot of concern on how the SABC is handling this matter, and that is why we are here. That is why there are people on strike at this point in time. So the SABC can very easily resolve this issue by simply withdrawing those letters, even if they want to do it on a without prejudice basis, and come with an open mind to then consult with us. They are not robbed from that opportunity.
So just, briefly, we know that the court has reserved judgment, and we will hear the judgment come next week, Wednesday. Are you optimistic? Do you see this going in? How do you see this going, the judgment going?
Yeah, it's actually not a good thing to predict what the outcome will be. I think, in particular, I think courts do not like that. But I think our lawyers and our counsel in particular has made very solid legal arguments that the SABC has not disputed in their papers. For instance, that there is nowhere in their papers where they have actually shown the court that they have consulted on, for instance, selection criteria and severance pay and those issues. So we believe that the court will find that there is, in the absence of evidence being presented by the SABC, that the court will find that there was no consultation. I don't think it's a difficult decision for the court. The SABC has already conceded to the consultation process. We actually just want that to be in court order and then to have those letters removed so that people don't walk around with a target on their backs for the entire December and not knowing what is going to happen to them.
So one of the contentious issues here is the newly proposed structure, which many have said will prevent the SABC from being able to carry out its public mandate. We understand, based on the arguments here before this court, that there were two structures that were actually proposed, two different meetings, and this is basically the basis of which that the union has said that there was no consultation, and the fact that the SABC had been negotiating in bad faith. Please explain that process to us.
All right. So maybe just to correct you, when we talk about negotiation, it's not negotiation, it's consultation in bad faith. What has happened factually is that on the 12th of October, the SABC for the first time presented its structure. We have agreed at the end of that day that we will then come back. We came back on the 16th of October. On the 16th, from the 12th to the 16th, the structure that has been presented to us on the 12th has changed, with no input from no one, nothing whatsoever. And that was the concern. And of course, the concern is that there was no proper consultation on the structure, and that is what we have agreed. In fact, when we met after the board made the announcement of the 7 days, we met with the SABC. We made a proposal to them, not as the CEO said we have agreed with them, and he rectified that later in the meeting. We have made a proposal to them to say, will the board be amenable to a 30-day period, because 7 days is not going to take us anywhere. And once that 30 days seems to be amenable to the board, we are going to go back to members to seek a mandate on the 30 days. That simply changed now on the version of the COO to a agreement, which we then challenged him on, and he then changed that to say, well, there was an understanding. So the issue is that in this 30 days, and the SABC has already said so, in this 30 days we will deal with division by division, jointly unions, management, and we will go through those structures to have everyone's input. But, and this is the problem, if those letters are not reversed, what are we consulting about? What are we going to say to the SABC? To us, it says simply, the SABC is not open for persuasion on any input on the structure, and that is our concern.
Okay. And we heard counsel representing the SABC talking about the state of SOEs. Talk to us about your thoughts and your comments after hearing those comments.
Yeah, it's quite difficult to remain seated when those kind of false allegations are being made by counsel of the SABC. It seems that he's not been awake for the last 6 years or so. We are the ones who raised the issue of the previous board. We prepared a dossier with all of the irregularities. We were in the forefront in dealing with protecting the SABC 8 against the previous regime. All the corruption, all of those irregularities, we exposed them. So I don't know where he was, but we were there in the forefront fighting for the SABC to remain sustainable and have a clean administration.
Thank you so much for speaking to us. There you have it. That was BEMAWU President Johannes de Buisson, who was just responding to some of the questions that have come up following the proceedings that we've seen unfolding here at the Labour Court. One of those is that SABC employees did not stand up or speak up against maladministration and as well as the financial looting that has actually landed the SABC in the state that it's in right now. We've also heard a number of arguments and a lot of back and forth. We will hear the final judgment next week, Wednesday. Until then, we will just wait and see. For now, it's back to you in studio.
All right, Mbali Mthethwa, live for us there in Johannesburg. Thank you very much indeed for your reporting. Folks, that's a wrap off the agenda.